My overall contention is that the modern constitutional orders in which we all live are shaped as much by developments in legal thinking as by advances in science and technology. So with that statement, I'm actually contradicting something that has come to be known as the law lag, that the law lags behind science and technology. And I'll come back to that, but I have to declare myself an apostate. I do not believe that the law lags behind science and technology. So the tensions and accommodations between these two authorizing systems should therefore be of profound interest to all citizens of the contemporary world, as they bear on the definition of human entitlements, freedoms, and responsibilities. That starting position me to ask some further questions, which are summarized on that slide and which have been central to my own scholarship for decades. How does one think of a central pillar of legal thought, such as constitutionalism, if one understands constitutionalism itself as a space that the law functionally shares with science and technology? And how, furthermore, does the law seek to accommodate changing scientific understandings of nature and society within its relatively stable and unwavering categories? Last night, I spoke of one site where the techniques of fact-making in law and science bump up against each other very directly, namely in our understanding of what counts as truth or expert authority, especially in the public domain. Tonight, the site I want to investigate with you is a little less obvious. It is our sense of time and the relationship of time to responsibility. I hope to show that ideas of time are another site where the law is in constant interplay with science and technology. Both modes of thought aim to define the temporal horizons within which we examine our existence, and a reckoning with time is essential to configuring the territory within which legal ideas such as causation, duty of care, and precaution acquire meaning. The common law loves proximity as much as it hates the speculative and merely conjectural. Back when I studied torts in law school, the unfortunate case of Mrs. Helen Palsgraf was the classic cold open used to bring this point home. As every American law student learns, Mrs. Palsgraf was standing innocently at one end of a platform used by the Long Island Railroad, awaiting her train. Two men ran to board the train before hers arrived. As railroad employees tried to help one of them, a small newspaper-wrapped package he was carrying fell to the ground. Unhappily, the package contained fireworks, which exploded, setting off a tremor down the platform. This caused a heavy coin-operated scale at the other end to fall down and seriously injure Mrs. Palsgraf. She sued the railroad and at first won compensation, but her claim was overturned on appeal by the great judge Benjamin Cardozo, then Chief Judge of New York State's highest court. Cardozo ruled that whether or not the LIRR employees had been negligent, Mrs. Palsgraf was not entitled to compensation because she didn't fall within the zone of persons to whom care was owed. Proof of negligence in the air, so to speak, will not do, Cardozo said. To establish liability, negligence must rest on some tangible relationship of care between defendant and victim, a kind of proximity. Under the facts of this case, there was no such near relationship between the claimant and the railroad or its possibly careless employees. Mrs. Palsgraf lost her case, though, as the folk culture of the law attests, her name became immortal.
The scale tipped and fell upon her. Was it negligence or fate? He sat and heard her tell her story, how she would be forever lame, and at the end of her sad story,
So, for our purposes, Mrs. Palsgrave's case is most instructive because it speaks to the law's imagination of what actions a person or entity is responsible for in the light of what can be predicted or foreseen. Any event, after all, can be described as the endpoint of a chain of smaller happenings linked together to form a seamless narrative. The English poet George Herbert apparently was the first to collect the children's rhyme about the missing horseshoe nail, for lack of which a horse, a rider, a message, and in some versions an entire battle were lost. That trail of events imitates the law's techniques for establishing but-for causation. But for a particular precipitating event, the downstream consequences would have never happened. But where does morality step into the causal chain? Should we hold the nail maker responsible for all of those later losses? Or, with the passage of time and intervening agency, has the succession of events become too attenuated to trace responsibility fairly back to a single point of origin? If we had to take responsibility for every consequence in which our acts, however minuscule, have played some part, we might become infinitely liable for the state of the world, or else the question of responsibility would become so dispersed and diluted as to lose all meaning. This is the sort of infinite regress that law time, in some measure, is intent on preventing. Interestingly, nails played a distinctive part in the causal story about modern locomotion adjudicated in Kumho Tire versus Carmichael, the third case in the US evidence trilogy that I mentioned yesterday. Here too, time and its passage had something to do with the ultimate judicial ruling. Kumho involved a tire blowout that caused a vehicular accident in which one person died. Here, the question was whether an acknowledged tire expert who had worked for Michelin for 10 years could, on the basis of his expert judgment, attribute the tire failure to a manufacturing defect rather than to the effects of overuse. In particular, the record showed that nails had punctured the offending tire and that 2 puncture wounds had been repaired in the history of the tire's past use. So there you get the immortality, the timelessness of theory confronting the timeliness of the tire's life. Chief Justice William Rehnquist cautioned against letting expert theorizing override the lived life of the particular tire in the case, a history that anyone who has driven a car with worn tires could assess on the basis of common knowledge. Did the expert, Rehnquist asked, have a theory that could differentiate the indicators of defective manufacture from the specific history of this tire, including its recorded encounter with nails? If there was no such generally accepted theoretical explanation, then the expert was no more expert than a layperson endowed with common experiential knowledge. One can think of such cases as involving a time span with numerous intervening variables in economic terms, and clever formulas can be devised to apportion responsibility among multiple causes. The doctrine of joint and several liability in the law makes it unnecessary for the law to distribute responsibility precisely across multiple possible causal agents. That task would be burdensome at best, and with long time lapses, impossible at worst. But tonight, I want to speak more about some of the tensions that have arisen because of science's increasing power to retrace and to predict events over temporal sequences that surpass normal human reckonings. That capacity to both look back and historicize and look forward and foretell does not always sit comfortably with the law's understanding of events framed by an original or ur-text, such as a law or a constitution. So I want to say a little bit now about law's ideas about originalism, because that's the textuality that ties law time down to some extent. How do we determine the true meaning of a written text? If that text has a quasi-sacral quality, then one easy institutional solution is to anoint a priestly class to whom society delegates the exclusive right to make authoritative interpretations. This, in effect, is the role played by constitutional scholars and judges, but as we saw last night, even people trained as professionals in the same legal tradition can differ on how to establish the truth of an original text. Just such a dispute arose, as we saw, between Justices Roberts and Kagan in the Loper versus Raimondo case, which overruled the Chevron doctrine of deference to administrative interpretations of ambiguous laws. As I discussed yesterday, Chief Justice Roberts insisted that statutes, when enacted, have a single best meaning, and that only courts are equipped and authorized to announce what that meaning is. By contrast, Kagan argued that statutes regularly are more open-textured, and even that they have to be to allow for changing circumstances. Therefore, we need additional information from subject matter experts, she said, to carry through the legislature's intent. Thus, to implement the Clean Air Act, one had to interpret in Chevron the term stationary source more precisely than Congress could have foreseen as necessary. It was right and proper under Kagan's reading to allow the Act to evolve through time with expert administrative agencies filling in the blanks in the legislative fabric without constant need for congressional supervision and reapproval. As Akhil Amar also observes in America's Unwritten Constitution, to discern the Constitution's original meaning, it may be necessary to go outside the text. Amar himself provides material evidence to make this point. In the late 1780s, he says in his book, several different versions of the text circulated among the citizenry, each calling itself the Constitution. Each featured slightly different punctuation, capitalization, and wording. Which specific written version was and is the legal constitution? To find the answer, Amar says, we must necessarily go beyond these dueling texts themselves and consider things outside the texts. When we carry out this investigation, he adds, we will find that the parchment so carefully preserved and displayed in the National Archives is not and never was the legal version, although this celebrated parchment does happily, he says, closely approximate the official text. This turn to materiality to fix an object's meaning is something an STS scholar might applaud in practice, but Amar's willingness to concede that there were many physical constitutions sits awkwardly with his insistence on a text-based originalism, a blueprint, as he puts it, for making sense of the document's wording. The constitutional historian Jill Lepore, my Harvard colleague, has a very different take on originalism, which she labels a philosophy and rejects as a historical position that the framers ever subscribed to. Indeed, on her account, the amendment process authorized by the Constitution speaks to a sensibility that the founding document would have to change with time and circumstances as the people willed it. For Lepore, and I quote, the Constitution's history does not lie in the archives of the Supreme Court. The Constitution's history lies in the hearts and minds of the American people, and that has been a long history of contestation and argument and division and union, she says. That contestation occurs to some extent, but only in part, within the court and the legal system. The makeup of the judiciary changes, even if change is slow, and in some degree, those changes track broader shifts in social and political thought. The famously activist and liberal Warren Court was headed by a former state governor who was also the last elected official to serve as Chief Justice. In the politically tumultuous 1960s, a background in politics may have led Earl Warren to conceive the role of the law and the courts in a different light from judges trained in textual interpretation as an end in itself. But whatever intellectual background judges bring to the federal courts, a central challenge of the later 20th century has been to confront social transformations associated with scientific and technological developments with the interpretive machinery of the law, which tends to prefer stasis and incremental change. When the Supreme Court ruled that racial segregation in schools is unconstitutional, in a review process that included expert contributions from the social sciences, Felix Frankfurter, a noted advocate of judicial restraint, joined the court's unanimous and revolutionary opinion, but he also advocated for including the phrase "with all deliberate speed" in the implementing order so as to give U.S. school districts more time to comply with Brown v. Board of Education. Less known is the source of that language. It comes from Francis Thompson's 1890 poem, The Hound of Heaven. The poet, seeking to flee God, finds he cannot escape the feet of the divine hound as it approaches with unhurrying chase, an unperturbed pace, deliberate speed, majestic instancy. Frankfurter, too, evidently felt the unstoppable force of history, and he gave way. From the disciplinary standpoint of STS, what matters is not just whether a decision is right or wrong, correctly or incorrectly argued, or consistent with some particular theory of doctrinal coherence. Rather, STS scholars are interested in exploring how an imagination of the Constitution how it works and how it gets into the hearts and minds of people, as Gilles Lepore asserted. For this purpose, powerful evidence is likely to come from sources completely outside the law, as from inside of it. Such evidence may come from popular culture. Indeed, it may come from the time-transcending, trans-historical, interstellar world of Star Trek. Where Frankfurter and his law clerks turned for inspiration to the classics of English poetry, Americans are more likely to turn to television. In the 1960s, TV audiences were captivated by Star Trek, a series that followed the adventures of the ethnically diverse crew of the Starship Enterprise and aired from September 1966 to June 1969. Few episodes of Star Trek, the original series, have come in for as much scorn as Gene Roddenberry's vanity script, The Omega Glory, which he insisted on making over considerable opposition from his studio colleagues. It has been consistently panned since it was first aired on March 1st, 1968. But as I believe a viewer of the original airing, I must attest that it left a lasting impression, enough so that when I talk about it today as exemplifying how a history of constitutionalism can indeed be carried in the hearts and minds of the American people, as Lepore suggests. Omega Glory is a parallel universe story. The Star Trek crew lands on a planet where a vicious war is being waged between the Yangs and the Coms. The villain of the story is a survivor from an ill-fated prior mission who is violating the Prime Directive, the founding principle of Star Trek's constitutional order. And he's violating it by intervening in the local conflict. As some of you may know, Star Trek is under strict injunctions never to intervene in the planetary affairs of the places that the Enterprise goes to. At some point during their brief time on this planet, Captain Kirk and his crew become aware that the barbaric Yangs, led by their chief Cloud William, are really descendants of Yankees. And the Holy of Holies that they reverence is nothing less than America's founding documents. In the concluding scenes, Kirk reveals his own knowledge of the texts, offering his version of Akhil Amar's contention that modern constitutional thought is American constitutional thought. Only in Kirk's mouth, originalism takes a somewhat different spin. Let's look at a clip together.
This was not written for chiefs.
What's your ring not written for chiefs? Of course there is for Chief Wilson.
Hear me. Hear this! Among my people, We carry many such words as this from many lands, many worlds. Many are equally good and are as well respected. But wherever we have gone, no words have said this thing of importance in quite this way. Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words, proudly saying, "We the people." And the words that follow were not written only for the Yangs, but for the Calms as well.
Calms?
They must apply to everyone, or they mean nothing. Do you understand?
I do not fully understand. One named Kirk. But the holy words will be obeyed. I swear it.
We merely showed them the meaning of what they were fighting for. Liberty and freedom have to be more than just words.
Doctor.
Gentlemen, the fighting is over here. I suggest we leave them to discover their history and their liberty.
So as the Enterprise crew was preparing to leave, the constitutional moment came because Spock wondered if they too had violated the Prime Directive. And so those last words that Kirk utters were words of reassurance. No, we didn't, is his point. We merely showed them the meaning of what they were fighting for. Liberty and freedom have to be more than just words. Gentlemen, the fighting is over here. I suggest we leave them to discover their history and their liberty. So one response to this incredible exchange is to laugh out loud. And for that purpose, an extract from a Reddit fan thread, in effect, nails it. Sometimes, and I quote, "Sometimes you just need a Canadian actor playing a guy from Iowa who'd spent at least a few years of his youth off-world getting weirdly enthusiastic about the American Constitution in that uniquely American way." A more serious response, though, is that the Omega Glory episode offers us its own viable reading of what connects a written text to a people's desire for legitimate self-governance. In this imagination, channeled through the creative instincts of a Gene Roddenberry, the Constitution has meaning only because people choose to accept it, treat it as holy, and weave its words into their practices of sociality. It may be necessary for a sort of originalism to come back from time to time, an actor, Canadian or American, able to recite the text as Kirk does without slurring it. But even Kirk's reminder of what liberty and freedom might mean to the Yangs and the Calms carries weight only because the Yangs cared enough to keep the ancient document holy and hence relevant to their present circumstances. And that impulse of constitutional renewal, even constitutional agency, comes from the 3 words written larger than the rest that Kirk points to, "We, the people." Akhil Amar said, and I quoted him yesterday, "The world, in short, is increasingly American, and the ideas of that modern world are the ideas of the American Constitution." But seeing this hammy Star Trek episode reminds us of the myriad ways in which the materiality and practice of constitutions must link up to give life to an idea that carries through the ages. Is it a Roddenberry or a Roberts who ensures that the ideas of the modern world are, or maybe more modestly include, the ideas of the American Constitution? That is a question. Let us return now more directly to judicial constructions of temporality as they relate to changing perceptions of the world and of society's norms of responsibility. In their commitment to empiricism and proximity, common law courts were once unwilling to consider any claims of harm that were not imminent and hence measurable by common sense assessments of likely damage. In 1885, in Fletcher v. Bealey, an English court confronted a request for a restraining order by one riparian property owner against another. The plaintiff, a paper manufacturer who needed very clean water for his industry, contended that his upstream neighbor, an alkali manufacturer, was depositing that waste from his plant close to the river at the rate of 1,000 tons a month, creating a potential hazard. The consequence, asserted in rich Victorian prose, would eventually be catastrophic for the downstream enterprise. As the case notes say, in the course of a few years, a liquid of a very noxious character would flow from the heap and would continue flowing for 40 years or more, and that if this liquid should find its way into the river to any appreciable extent, the water would be rendered unfit for the plaintiff's manufacture and his trade would be ruined. The court refused to grant the requested relief. The injury was simply not close enough to merit relief. There must be prospective injury about which there can be no doubt, the court said. Merely speculative or possible, even probable injury will not do. Besides, there was always the chance that things could end up less disastrously than the plaintiff feared. Judicial optimism, techno-optimism we might say, took over. I think that in 10 years' time, the judge said, it is highly probable that science, which is at work on the subject, may have discovered some means for rendering this green liquid innocuous. Fast forward across decades and oceans, and we encounter a different judicial mindset in the leading environmental cases of the 1970s in the United States, such as reserve mining versus EPA in 1975 and Ethel Corp versus EPA in 1976. In these cases, courts were confronted with two sets of changes that affected their understanding of the relationship between time and responsibility. First, there was growing scientific evidence that industrial activities undertaken today do not exhaust their harmful potential within immediate or even foreseeable time periods. Diseases like cancer, respiratory ailments, lowered fertility, and neurological damage can result from low-level exposures over long periods. Hazardous working conditions, as in the mining and farming industries, may produce unexpected health impacts later in life and even into the next generation. Rachel Carson's 1962 book, Silent Spring, widened the scope of environmental concern and environmental scientific debates beyond humans. Not only people, but plants, animals, and ecosystems might all be at risk from prolonged exposure to the side effects, or in economic terms, externalities of industrial activity. All were vulnerable to the long-term impacts of humans' growing footprint on the earth. Second, the basis for judicial action shifted during the 1970s from the common law framework of negligence to a dense network of new statutory obligations delegated to federal regulatory agencies. Along with the growing predictive power of science, driven by advances in detection, measurement, and modeling technologies, the focus on harm or tangible damage shifted to a concern with the more nebulous concept of risk. Ethel Corp, a particularly influential decision, confirmed that agencies need not wait for definitive proof in order to take protective action. This is the place in American law where a basis for precaution was being laid. EPA was authorized, and I quote, to draw conclusions from suspected but not completely substantiated relationships between facts, from trends among facts, from theoretical projections from imperfect data, from probative preliminary data not yet certifiable as fact, and the like. Moreover, instead of insisting on a fixed quantum of harm, regulators could weigh the gravity of the threatened harm against its likelihood. That is to say, the court said, the public health may properly be found endangered both by a lesser risk of greater harm and by a greater risk of a lesser harm. In the 1970s, we were not yet aware of climate as a matter of urgent concern. For that, several other convergent strands of knowledge and norms needed to fall into place through a process of co-production that has few analogues in human history. Here is a new subject of global concern that we cannot touch, smell, hear, see, or feel. Like some unseen monster in a horror movie, climate change is knowable only by our willingness to piece together a story from precisely the sorts of partial knowings mentioned in Ethel, from suspected but not completely substantiated relationships between facts, from trends, from theoretical projections, and from preliminary data not yet certifiable as fact. For such ephemera to cohere into a single story about the human future that we accept as true, a story that compels political action now, the convergence of knowledge and norms needed to be multi-sided, compelling, and consistent with humanity's preferences for how to live in the world. STS scholars and their activist allies have written both supportively and critically about the emergence of climate change as a focal point of global policy and international relations. There are detailed accounts in the literature of the massive technological apparatus that had to come together to support the claim that climate change is real and urgent. This includes both material and social components, from the Mauna Loa Observatory's records of rising CO2 concentrations and general circulation models to the Intergovernmental Panel on Climate Change, whose 6 assessment reports provide encyclopedic coverage of what we know and don't know about this elusive yet profoundly disruptive phenomenon. Not all of this literature is uncritically accepting of the climate consensus as it has been developed for policy. In particular, through the first 3 decades of the IPCC's work, policymakers refused to grapple directly with the historical realities of climate change, that although all of humanity was vulnerable to climate's destructive power, not all of humanity had been equally responsible for bringing this monster into the world. Early efforts to divide emissions into distinct categories of concern based on the nature of the emitting activity went nowhere as a political matter. The idea that so-called subsistence emissions, the byproduct of poor people's essential livelihood, represented on this in this well-known cartoon by the guy with the donkey trying to cut down a tree for timber. So the idea that these subsistence emissions should not be treated the same as luxury emissions, the product of rich people's non-essential consumption, made no headway in global political discourse. Instead, the idea of a single market for carbon flattened history in order to build support for addressing our common future. Yesterday, someone asked me if we can use co-production to change the world. I, of course, fell back on the legal academic's technique of saying, in effect, it depends on what you mean. I did say further that we first need to understand the co-produced character of the circumstances we're in so that we can identify which aspects of the world we want to reconfigure. Climate change offers an opportunity for just this kind of analysis, and those of you who were here yesterday can see in the working out of this example a more extended answer to yesterday's thought-provoking question. Today, largely but not solely because of political developments in the United States, 2 opposing movements are forming to co-produce a different climate consensus from the one imagined by the IPCC and 30 years of conferences of the parties. One movement, represented by the youth climate actions that have sprung up around the world in the last few years, seeks to redefine climate change as unjustly rewarding some forms of current economic and social behavior at the expense of burdening the future for others. This movement is driven by concerns about justice. The other movement wishes to redefine climate change as a manageable object and not a runaway threat that humanity must do everything in its power to stop before it destroys us. This movement is driven by theories of economics. In each of these emerging re-articulations of the climate change phenomenon, we see that the normative role of time is integrally involved, along with the material steps that must be taken to realize the movement's objectives. Juliana versus US lends itself to analysis as a modern-day children's crusade. The case features similar elements of youthful enthusiasm, a passionate cause, an unequal struggle against immense odds, and a succession of failures. Juliana's decade-long struggle attests to the strength of a capitalism that for centuries accepted the harmful environmental effects of industrial development as a necessary component of its growth paradigm. In 2015, an environmental nonprofit called Our Children's Trust filed a lawsuit against the US government, the president, and various executive branch agencies on behalf of 21 young Americans. They said that the government's actions supporting the extraction and burning of fossil fuels had destabilized the climate system with threats of loss that violated the children's constitutional rights to life, liberty, and property. In choosing to couch their claim in constitutional terms, rather than as a challenge to particular agency actions, the plaintiffs sought to deflect the case in the direction that accords supremacy to judges towards the practices of constitutional interpretation where there is no other branch claiming to share the stage with the judiciary. In November of 2016, U.S. Judge Ann Aiken of Oregon ruled in favor of the plaintiffs on all key grounds, refusing the defendants', that is the government's, motion to dismiss the case. The plaintiffs had raised a question that was justiciable, that is appropriate for the courts and not simply political. They had standing to sue and had met the requirement of causation, and perhaps most importantly, they had shown that their complaint could be redressed by judicial action. Ultimately, on appeal, the Ninth Circuit ruled against Judge Aiken, finding that the case did indeed raise a political question and denied standing to the plaintiffs. The Supreme Court refused to review the appellate court decision, thereby bringing the Juliana saga to an end for purposes of the American legal process. For our purposes, however, the case may live on, not only because it provided inspiration for other young litigants in other jurisdictions, as Juliana did, but because it will continue to serve as a conceptual milestone for the construction of time and responsibility in U.S. environmental law. The Aiken decision can be read as a treatise on legal timekeeping at many levels. It had to address the government's plea for stability and continuity, as agencies argued that 100 years of work and assumptions would be undone if the children prevailed in their legal crusade. It had to address whether the requested remedy to develop a plan for the management of greenhouse gases could be realistically undertaken by the government, and whether trying to ensure compliance with a court-ordered remedy would force the judiciary to cross the line of separation of powers and impose on the court an ongoing and unrealistic supervisory burden. Most immediately, and consistent with my preceding discussion of common law thinking about the environment, the court had to address the question of imminence, and that section hinges on time as a key variable of co-production and constitutionalism. In seeking an injunction, the plaintiffs had to show that the danger they wished to avoid was imminent, that is, sufficiently likely to occur to justify the court in issuing an injunction in the first place. Judge Aiken ruled that they had succeeded in meeting this basic judicial test. The harm they complained of was ongoing and likely to recur, and this judgment she reached on the basis of scientific findings and the scientific record. More specifically, the plaintiff had shown that the present level of CO2 and its warming, both realized and latent, are already in the zone of danger. They had also successfully shown that, and I quote, "Our country is now in a period of carbon overshoot with early consequences that are already threatening and that will, in the short term, rise to the unbearable unless defendants take immediate action." And so in that quotation, you see scientific findings, in essence, disciplining judicial temporal preferences toward the direction of taking action for the sake of the future. This is a far cry from Fletcher v. Bealey's confidence that within a few years, science, which already was looking into the situation, would come up with a solution. It's worth underlining that the Juliana plaintiffs were seeking first and foremost a conceptual change in US constitutional law that would have brought about a new unenumerated fundamental right inside the four corners of the US Constitution, and thereby bring it more into line with the scientific and moral consensus formed by the United Nations climate regime. As Judge Aiken pointed out, the Constitution does not mention environmental policy, atmospheric emissions, or global warming. Nonetheless, she concluded that where a complaint alleges governmental action is affirmatively and substantially damaging the climate system in a way that will cause human deaths, shorten human lifespans, result in widespread damage to property, threaten human food sources, and dramatically alter the planet's ecosystem, it states a claim for a due process violation. In short, Judge Aiken only gave legal voice to what a co-productionist legal scholar would have seen at a glance. This was a lawsuit designed to expand the constitutional imagination to encompass a changing world. The science side of that changing world had acquired more solid institutional foundations than the law side, perhaps because science already was used to working across borders in ways that law has eschewed in its modern history. We might say that Juliana was seeking to correct for this imbalance through a modernization of American constitutional thought. The only question was whether the techno-human machinery of the law would prove sufficiently flexible and expansive for the activists' purposes, and for the time being, it did not. In the meantime, the consensus allegedly formed by the IPCC and the UN climate negotiation system was under attack from quite another theater of US decision-making, from within the Trump administration's bureaucratic apparatus. The timing of two almost concurrent legal moves sheds light on the radical character of the American turn away from an emerging international constitutional order. It also centered environmental legal thought at the epicenter of this geopolitical moment. On July 23, 2025, the International Court of Justice issued an advisory opinion stating that parties to the United Nations Framework Convention on Climate Change, including the United States, have an obligation to limit greenhouse gas emissions and cooperate with each other in protecting the climate system. On July 29th, the US EPA announced a proposal to withdraw its 2009 endangerment finding, an official declaration that 6 greenhouse gases endanger both the public health and the public welfare of current and future generations. If EPA follows through, it will gut the legal basis for reducing motor vehicle and power plant emissions under the 1970 Clean Air Act. It would also fly in the face of the ICJ's endorsement of climate science and international cooperation. It's easy to frame the EPA's proposed action as scientifically unsound and ill-advised. And many commentators have done just that. Others have noted that this would join a stream of actions that demote the United States from global preeminence in climate research, green technology, and environmental policy. China, it is often pointed out, will continue to innovate and dominate international climate talks, while America stagnates, mired in fossil fuel business as usual. There is, however, another reason for dismay, and it goes to the heart of democracy's accountability to technical expertise that I raised in yesterday's lecture. As I have argued, agencies like EPA are part of the constitutional machinery of democracy in modern societies. Their job is to enable us to act smartly in the face of uncertainty. How should a government know what to make of complex and changing scientific findings? How should it formulate policy balancing competing interests? Exasperatingly slow though they often are, independent agencies like EPA are tasked precisely to do this work. They are our chief safeguard against power exercised without the discipline of knowledge. The Trump administration argues that EPA overreached in curbing greenhouse gas emissions under the Clean Air Act. But as Don Price and many subsequent policy analysts have observed, Congress has neither the technical bandwidth nor the political will to take up that challenge and has delegated this authority to specialized agencies. As our knowledge changes to create new horizons of normative and temporal possibility, it's imperative then for our society to come to terms with its unwritten constitutional prescriptions and to apply them critically to forging a future in which enlightenment and democracy are not at war. I want to conclude tonight's lecture with a brief look at a very different domain of contestation where time, entitlements, and modes of constitutional interpretation are again in active interplay. As in the case of Chevron, this domain also involves an overruling of one Supreme Court decision by another. I speak here of the overruling of the 1973 decision in Roe v. Wade by the 2022 decision in Dobbs versus Jackson Women's Health Organization. For any woman who grew up as I did in the decades of expanding women's rights, the majority opinion in Dobbs landed as a monumental act of political backsliding. A high court of 6 men and 3 women, representing a small slice of the intellectual, moral, and gender diversity of the United States, handed down a decision that rolled back 50 years of growing control by women over their bodies, their selves, and their life choices. It ignored advances in science and technology that have reshaped how we think about reproduction and the meaning of life, as well as the degree of control people of every gender orientation feel entitled to exercise over aspects of biology that differentiate the sexes. Grounding the decision in a perverse originalism, as if one can write into law attitudes towards life crafted centuries before current biological and social understandings, is a form of anti-intellectualism that has on its face no place in democracies committed to protecting the lives and liberty of all their citizens. That said, those who dissent from Dobbs should not fall into the traps laid by the Roberts Court and the cheering US pro-life lobby by framing abortion solely as a matter of biological choice. The failure of Kamala Harris's 2024 run for the presidency speaks to the weakness of this construction of Dobbs as a vehicle for political and constitutional mobilization. Instead, we might begin with the observation that the life the Supreme Court and its supporters presumed to speak for is a life stripped of connection, purpose, and meaning. Dobbs reduced the cultural complexity of pregnancy, motherhood, and family in contemporary times to the right of each individual conceptus to be born alive. That reductionism flies in the face of women's hard-won claims to equal opportunity, though women continue to bear the chief burden of procreating and, in most cases, of subsequently nurturing the lives that are brought into the world. Historically, Dobbs cuts against the grain of contemporary gender politics and visions of human progress in the Americas and the West. One after another socially conservative, majority Catholic country has moved in recent years to liberalize abortion laws to give more voice to women. This is a demonstration, a typical Latin American country demonstration where the green flag has come to symbolize the stance for abortion rights. So among these countries, Italy, Ireland, Argentina, Colombia, Mexico, Chile, European countries have long recognized that respect for developing fetal life need not be tied to punitive abortion laws. Germany is an interesting case in point. Under German law, life begins at the moment of conception, and the country's basic law decrees that human integrity is inviolable. Nonetheless, Germans acknowledged that legal abortions are necessary to safeguard women's health and well-being, and recently eliminated a Nazi-era ban on providing information about abortion services. In the Netherlands, effective family planning and liberal abortion laws coexist with strikingly low numbers of unwanted pregnancies and abortions. These powerful currents of liberalism demonstrate a growing unwillingness in progressive societies to let the biology of reproduction dominate women's autonomy. They show that it is possible to insist on modern rights, to have the children we want and care for, to not have children if that is one's choice, and to take back the night from the darkness of Dobbs through a politics that is both pro-choice and, in the fullest sense, pro-life. But to achieve that ideal state of reproductive politics, we will also have to embrace ways of interpreting our relationship with time and history that are less asymmetrical and formal than the posture of the Dobbs majority. This is why it is important to choose between the originalist position of a liberal like Aki Lamar and the counter-reading of unwritten constitutions put forward by his colleague David Strauss, who insisted that Amar's own examples were not as textually grounded as he suggested they were. I quote one sentence from Strauss as shorthand. The preoccupation with the text obscures what is actually a very interesting story about unwritten constitutionalism, a case study in how a constitutional principle with a very weak grounding in the text not only can be adopted, but can become unquestioned and then extended. With slight modification, this sentence could just as easily have been written about Roe v. Wade and its progeny until Dobbs. The Supreme Court found great comfort in the decrees of great common law authorities like Bracton, Coke, Hale, and Blackstone, who all wrote that a pre-quickening abortion was a crime, and a serious one at that. Moreover, Hale and Blackstone and many other authorities following them, the Supreme Court said, asserted that even a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder if the woman died from the attempt. The court found less persuasive power in the historical arguments put forward by Roe's defenders, and they dismissed out of hand that liberty interests could encompass different ways of looking at abortion rights than those of the six-member majority. Indeed, they put forward a curious duality of mind and body that would alone be worth longer reflection and analysis, but I will just set it before you for now as a matter to reflect on. They said, while individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they're not always free to act in accordance with those thoughts. Yet, rights to bodily freedom are not static principles like preserved specimens pinned forever to the text of an aging parchment. Rights evolve in tune with changing understandings of how the world is. They're reframed in keeping with our knowledge, our capabilities, and our aspirations, which do include our ruminations on such abstractions as existence, meaning, the universe, and the mystery of human life. It is this dynamism, the freedom to imagine liberty and equality as knowledge advances and technologies change, that we should seek in trying to reclaim Dobbs's in trying to reclaim new constitutionalism from Dobbs's illiberal framing of what life truly means. I'll end tonight's lecture here, noting that we have advanced beyond yesterday's discussion by opening up a new site of constitutionalism, namely time, where legal understandings are a necessary, if inarticulate, conversation with what we know of the world and what we make of it with technology. I've suggested more particularly that the great constitutional disputes of our time, whether about human-environmental relationships or women's bodily freedom, rest on associated notions of history and memory and how to construct or deconstruct responsibility for our actions by adopting rules of constitutional interpretation in the law. Tomorrow, I'll carry this discussion forward into a fuller account of the interpenetration of law, science, and technology in shaping human agency and the human subject. Thank you again.